As of 9 December, the Telecommunication and Other Legislation Amendment Act of 2018 had amended a broad range of Commonwealth legislation to allow for law enforcement agencies to request and compel assistance in certain matters from telecommunication providers. As per the Act's explanatory memorandum, the primary purpose is to facilitate access to data, devices, and systems that are subject to a warrant where this material would otherwise be inaccessible. It is important to know whether your company will be caught by the Encryption Act. Section 317C sets out a user-friendly table of 15 categories that are designated communication providers and what the activities of those are. This Act is a catch-all definition which applies to a wide range of participants in the global communication supply chain that supplies communication services or products that are used or likely to be used in Australia. We strongly recommend you take a second on the slide to see whether the Act applies to you and your business. Now that you have identified that the Encryption Act applies to you and your company, you have to be aware of what can and can't be required from you to be provided. Section 317E of the Act lists all the things and acts which you may be required to do when you receive a notice from an interception agency. Law and government bodies can request or compel you to do the following: remove a form of electronic protection that was introduced by the provider, install, maintain, test, or use software and equipment, or facilitate access to facilities, and so forth. There are 3 notices and requests which may be provided to you. Each notice differs in its requirements and timeframes. A technical assistance request is a voluntary request with a limited oversight. This can be issued by the Directors General of the Australian Securities and Intelligence Organisation, the Australian Securities Intelligence Services, or the Australian Signals Directorate, as well as the Chief Officer of an interception agency. A technical assistance notice is a compulsory notice for a designated communication provider to issue an interception capability which they already have. This can be issued by the Director General of ASIO or by a Chief Officer of an interception agency. Lastly, you have the Technical Capabilities Notice, which is a compulsory notice for a designated communication provider to build a new interception capability to meet with an technical assistance notice. This can be issued only by the Attorney General after an ASIO request or through an interception agency with the approval of the Minister of Communications. When complying with a notice and request, it is critical to be aware of the timeframes to which you must comply. Each compliance period is determined on a case-to-case basis, and it is decided in consultancy with the telecommunication provider and interception agency. The default periods are 90 days for technical assistance requests, 90 days for technical assistance notices, and 180 days for technical capability notices. It is crucial to note that when a provider fails to comply with a notice, several penalties will apply. The company can be liable of a penalty of up to $10 million, and then an individual can be liable for up to $50,000. This Act may seem overwhelming. However, the relevant government bodies and agencies that will provide assistance and work alongside telecommunication providers when they've issued a notice or request. For more information, please follow the following sources.